2025 meeting of the Brisbane Planning Commission will now come to order. Staff, please call the roll.
Okay. Commissioner Funke?
Here.
Commissioner Gooding?
Here.
Commissioner Lau?
Sorry, here.
Thank you. Commissioner Saison?
Here.
And let the record reflect Commissioner Patel is absent.
Okay, adoption of the agenda. May I have a motion to adopt, please?
So moved. Second.
All in favor?
Aye.
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 Motion is unanimous. Next is a consent calendar, and we have none. So moving on to oral communications. If anyone wishes to address the commission concerning items not on tonight's agenda, please do so now. Staff, can you set a timer for, let's do 30 seconds?
Ten seconds. All right, 30 seconds has elapsed. No one's raised their hand.
Okay, thank you. Moving on to written communications, we have none for tonight. So I'll now turn to new business. Tonight we have a public hearing concerning 99 South Hill Drive. It's a sign program 2025-SR-01. It's in the TC-1 Crocker Park Trade Commercial District. This is an amendment to an adopted sign program to allow installation of 94.6 square foot of new building mounted non-illuminated signage, resulting in 286 square foot of advertising signage on the property with a frontage of over 100 linear feet. Stanley McCarthy of Sign City SF is the applicant, and South Hill 99 is the owner. Staff, may we have the presentation?
Yes, thank you. Good evening, Chair and Commissioners. So the applicant is requesting approval of an amendment to an adopted sign program for 99 South Hill Drive to add 3 new non-illuminated signs to the property and approve replacement or refacing of existing signs for a new tenant at the site. The sign proposal shown here on the screen, summarized in the staff report, about 96 square feet of new signs, non-illuminated, mounted at various points of the building for tenant uniload. This property is a site with multiple tenants and has a frontage of over 800 feet, so it's eligible for a sign program, which is basically any time there's signage on a property exceeding 100 square feet. Here's some more details of the proposed signs. And then there are proposals for refacing existing signs, which under the sign program requires only administrative approval by the planning director, but we're grouping it all together with this application. And here. So the staff also wants to note, it's in the staff report as well, some of the signs have been already replaced or refaced. One new sign has already been installed that's proposed before you tonight. Other signs on the property also have been modified at various times. So we do have a condition that we've added to the resolution to impose a penalty for any signs that were installed without planning approval required by the sign program. And those fees would be imposed either with a sign review permit that the director reviews or with building permits if the sign requires a building permit at 2 times the sign application fee. In terms of the findings for approval, the application generally meets all required findings to adopt or amend a sign program in Chapter 17.36 of the code. They're detailed in the staff report, and I'll summarize them here. So the program does conform to the requirements of Chapter 17.36, both in the requirement for a sign program. And of course, with a sign program, the overall size limitations do not apply to individual signs. The sign program prevails. The proposal will comply with all code requirements, including requirements to obtain a building permit, where the sign will be mounted over 6 feet in height above grade. The proposed signs are consistent with the scale, colors, and materials of existing development on the site and in the vicinity. This is not a coordinated sign program like what we've started to see out at Sierra Point. But again, for a multi-tenant site, the proposed signs are appropriate to the scale of the building and located appropriately to provide wayfinding to the subject business. And finally, the sign program as amended would be consistent with the general plan. There is no specific plan applicable to the property or PD permit, but we do have general plan policies encouraging supporting our local business economy. Installing business signage is obviously one way to achieve that, among others. I'll conclude my staff report there, and we are recommending conditional approval, subject to the findings and conditions outlined in the staff report, and I'm happy to answer any questions.
Okay, thank you. Any questions for staff? Commissioner Funke?
I had read through the material before, and I don't find anything objectionable here. I just have one sort of theoretical question here, which is the conditions or the basis for the evaluation always does seem to be somewhat subjective. It's like it's consistent with the needs for, to finding your way around an industrial park. I just wonder what kind of sign it would have to be for you not to recommend. I agree, this one is completely unobjectionable, but how big would it have to be exactly, or what would the character would have to be for you to say, this is one step too far?
I think it is kind of subjective, and obviously it's hard to speculate, but if we're going to speculate, I would say, if a tenant proposed a sign that took off a quarter of the building wall on a multi-tenant site, that would seem to be out of scale with the development. This is a 2- and 3-story scale building.
It's like a reasonable person standard or something.
I think so. Yes. Okay. Yes. And design, from a design perspective, like the proposed signs are basically the tenant's trademark or, their logo mark. So, we don't have a ton of wiggle room with imposing like changes to, if it's their text, it's their font that they use, it's their logo that they use. Those are things that are not something the city typically can require to be modified. So, yeah, I think the universe of what is unreasonable or not complimentary is kind of, it when you see it.
Yeah, you wouldn't have known driving by that this required any sort of review or anything. And then I wonder, my second one was, apparently here also some of the signs had been replaced without asking for permission. And is this something that someone in that position should have known? It's like, I'm going to do the sign. Oh, there's probably, probably have to go see someone about this. Is that true? Like you should have known, they should have known?
So this is a multi-tenant property. There's a property owner, obviously. Property owners are authorize any planning application. So, certainly the property owner was aware in 2012 of the sign program that applied and its requirements. Whether or not those requirements are being reflected in like lease terms, I would guess, I cannot speak for the property owner, but I would guess generally a property owner might say that's up to my tenant to ensure they're following all code requirements for improving the site, just like they would need to get a building permit to do a tenant improvement and verify what code requirements might apply to that. But that is, again, kind of speculative. The property owner is made aware and authorizes the application. They're made aware of action on the application, and as is the applicant who is working directly with the tenant.
Okay,
So.
Thank you.
Okay, thank you. Commissioner Lau?
My only question out of curiosity, kind of extending on Commissioner Wonka's question was, just curious, was the application for the signs, was there a complaint about the sign already brought up and
No.
initiated this, the application?
No.
Okay.
No, they contacted the city in this case and said, we would like to install new signs. What are the requirements? We directed them to the planning application and proceeded to process it.
Okay, Commissioner Gooding?
Yeah, thank you. I thought I saw something in the materials about a penalty being assessed for failure to have originally applied for permission. Is that correct?
The penalty would apply to any signs that were not installed with planning approval as required by the sign program.
So have these signs already been installed and now they're just asking for forgiveness? Is that
One
essentially?
of the proposed signs was installed, and let me see if I can navigate to that. Sign P2. Sign P2 is currently installed. This is an access gate going back to the loading docks.
And how,
These signs were not.
and how did this come to the,
Staff did a site visit, as we always do,
okay.
and observed the condition.
And I think I noted that there is a penalty being assessed as a condition of approval of this. Is that correct?
Yes. For the, assessed on the building permit, it'll be twice the sign fee.
So it's twice the usual permit application fee?
Correct.
Okay. This is one of the bees in my bonnet about permission versus forgiveness, and I was glad to see that there was a penalty being assessed because clearly folks in this business know that there's rules about this, so because that's one of the conditions of approval, I will be inclined to vote yes.
Okay, thank you. I have no questions, so we'll now open the public hearing. Is the applicant here?
The applicant is not here.
Okay, so, well, without the applicant here, shall we still move forward, or is this a situation where we need to continue for their appearance?
We're going to confer for a minute.
Okay.
Okay. We can move forward without the applicant present to move on the application if you don't have any questions of the applicant that you feel are necessary to make your motion.
Okay. Well, let's see. Let's give the public an opportunity to speak. So why don't we set a 30-second timer?
Thirty seconds has elapsed. No one's
Okay.
raised their hand.
Thank you. May I have a motion to close the public hearing?
Also move.
Okay, all in favor?
Aye.
Okay, motion is unanimous. Okay, discussions. Well, I think it's kind of unusual that the applicant is not here. But I think just based upon staff's report and what has been submitted, I think we could, unless anybody has any comments, I would think we can just move forward. Any comments?
Just a brief sort of a policy addressed comment, which is I appreciate that the staff does not have the power to enact or to impose any penalty stronger than that is provided in the code. As one of five, I would at some point advocate for the council to take up the issue of, when people, it seems like a significant proportion of the permit applications that we get recently have been people getting caught rather than people coming to ask for something that is reasonable. I don't think these signs are unreasonable. I'm just disturbed by the pattern of not asking for approval, but asking for, for forgiveness on the back end. We enforce the laws that exist, and under the laws that exist, I don't see any reason to say no on this one. I've just had my say, and I'm done. Thank you.
And to confirm with staff, so we are imposing the max penalty that we can on this applicant?
No, I believe the code allows 10 times.
Oh.
So yes, the code would allow a much higher fee to be imposed. We can't say when this sign was installed. I agree. It's not following the code to install a sign before the commission has approved it, but they did initiate this application 3 months ago or more, and have been diligently pursuing it. We're aware that your approval was required. So that's the background I can provide on it.
And you said that the penalty that staff had earlier said would be double?
2 times.
I mean, I would entertain, because I think it's somewhat, appalling that to have done what they did and to not show up tonight. So I would not mind and if entertaining increasing that penalty. Would anyone be opposed to 5 times instead of 2? I mean,
What's the absolute amount? I don't know.
10. She said 10 times.
Oh, no, but like the size of the penalty.
The size. Julie, what is the size of the penalty?
It would be the sign program application fee, which I'll have to verify, but I believe it's somewhere in the realm of $1,000. If you give me a moment, I can look it up.
So that's the application fee, and you're saying 5 times that.
Well, let's see her. Julie, can you confirm?
Thank you. Yeah, so the present fee for sign program amendment, which one of the signs installed, or the larger sign that was installed would have triggered that. It's $1,000 at $1,066.
And so currently then staff would be imposing about a $2,000 penalty.
Correct.
And so if we increase, any thoughts on?
Is it just, is it at the discretion of the department to determine the amount of the penalty, and can the commission make suggestions or recommendations on, such penalty fees?
Let's pull up the code section so that we can see what the code actually says. And we'll give you guys an update in a moment. So Thank you. So we looked at our fee schedule, the city's master fee schedule, and the fee schedule contains a zoning violation penalty of 10 times the original fee. And that's all it says. Yeah, so the way we've interpreted it is that's a maximum. And you know, a zoning penalty could be assessed anything up to that maximum. And we've suggested a 2 times penalty. Yeah. We did have a memo to you guys a month ago, perhaps, I think, one of the meetings in July that addressed how we impose zoning violation fees. If we want to pull that up, are you doing that right now?
May I ask for?
Would you like us to pull that up so we can?
That's, well, if you like, but I have one other question. Is how in the sort of process did this violation come to light, and on whom is it being imposed? Is it only on the tenant or on the owner, or both?
It would be on the applicant, so who's representing the tenant. We wouldn't be finding the owner in this situation.
Thank you.
I think, through the chair, if I can expand a little bit, I think in a situation where there's been use violations on a site, there might be a clearer line in that type of situation to involve the property owner. But yeah, in this case, it would be imposed on the applicant.
Okay, does anyone have any thoughts on?
Just one question. Was it communicated to the applicant, you know, that it might be a 2 times fine?
Yes, the applicant was provided with a copy of the staff report. So they're aware of it, and we received nothing from the applicant contesting that.
Yeah, I would think if they had any concerns about the fine and wanted to plead their case, they would have showed up tonight or show up regardless. So that doesn't seem to be a concern. So I'm inclined to increase it as to how much, or recommend that we do. If we're going to approve this,
we could, through the chair, we could continue it.
We could,
which would also allow the applicant a chance to respond. And we could bring back a revised resolution. I think that is an option for you guys.
well, I kind of think, we're all wasting our time here. It's not like if something came up, I would think they would have contacted staff that they couldn't be here for some reason. But, first they went on with their signage without informing the city, and now they don't show up for their hearing. So I don't think we should continue it to give them another opportunity unless, I don't see any good cause presented. So, I think we either keep the penalty the same as staff has recommended, but I think when staff recommended it, we thought the applicant would be here. So, I'm inclined to propose so it's currently double, maybe triple, maybe more. I'm open to thoughts.
I would agree with your initial 5 times, which was
Okay.
half the max penalty.
Okay, Commissioner Funke, what about you?
I don't object to increasing it. There is another part of it that says that since the applicant's already been told 2x, I'm not sure whether this is the one you want to make an example of. I wonder if the size of the penalty, like the multiple of the application fee, if that's something that should be kind of run by here, depending on the egregiousness, or just by staff. We might have said that it should be more upfront. Maybe not for this case, but for the last one. I think this is particularly mild. I could sort of imagine someone saying, "Hey, we need to refresh the signs." I could see it being an oversight that I can't get too excited about. I think last week's or the last meeting, removing 10 times the amount of dirt, that seemed, I think there was more there. There was more dirt there that might have warranted not just the twofold, but a tenfold or fivefold. But maybe the size of the penalty should be discussed before it's communicated. That's one thing I
But
have.
I agree with your point, but at least they showed up. They were here trying to explain and plead their case. And, so that I could, empathize a little bit. I just think just not showing up or advising staff at all, I'm not quite sure what that is about. So,
So it's kind of a no-show penalty, in addition to.
no show, but I think it adds to the initial flagrants in terms of just ignoring, because I think staff said they were aware that they had a duty to advise staff that they wanted to make these changes to the sign, but they went ahead and did it. So to me, this is 2 strikes on them. The first strike, they did it without telling anyone. The second strike, to not even show up at your own hearing, So yeah. Commissioner Gooding, what about you?
I don't have a hard line about how much it should be. I just think we should increase it somewhat to begin making the point that violations of the rules have consequences. If we're going to increase it substantially, it might be appropriate to give them a chance to appear. As a practical business matter, I suspect they saw the penalty and said, well, we can live with that, so we're not going to contest it.
Well, let's say Julia, if we were to, let's say, increase the penalty 5 times, they could appeal it, right? So that would be the natural step that they could do.
Correct. They could submit an appeal and go to the city council.
Right. So, why, if let's say we continued this and then they came, what do you envision would happen at that, would we, I don't know what explanation I think they could offer that I would say, okay, we'll take it back down to 2. Because then it would just be kind of wasting all of our time to continue it for, I can't imagine what the excuse would be. I think we either keep it at 2 times, but if we're going to increase it, go ahead and increase it, and there's a process for them to appeal. I think that's their opportunity, not a continuance.
Do we, is there a state of mind thing here? I'm just curious. You said something that the applicant knew that they had a responsibility.
Staff said that they knew what the rules were.
Go ahead. Looks like you're about to say something.
Well, sorry, I thought Commissioner Funke was saying one thing, but then Commissioner Sayasan clarified. In terms of the applicant being aware of the requirement to obtain planning approval and building permit approval in some cases before installing the sign, yes, that's accurate. When they reached out to staff and asked what the process was, we shared that process, prompted them to submit their application. So,
all right.
like I said, I'm not sure when, I can't say when the sign installation occurred. All we know is that it was there as of a week ago. One of the signs, sign P2.
That seems important to me too, because that seems more willful in a way. I just thought it was someone hanging signs. It's like, oh, I didn't know I needed a permit, which I know ignorance is not an excuse, ignorance of the law, but in this case, it's like it wasn't even ignorance. It was willful, like we knew and we did it anyway. So that makes me more inclined to go along with what you're saying.
Yeah, that's why I was thinking this is their second strike, because they also knew they had a hearing tonight and they should appear, and they just don't show up without notifying anyone. So I think to what Commissioner Gooding was saying too, I think, it's at some point we need to kind of let applicants understand that there's consequences to action. And I think we need to also, when we make our decisions, think about a deterrent effect, right? I think there's a message that needs to be sent that, folks can't keep on thinking that they can violate the code and we'll just let it slide. So So I think I suggested 5 times. I think Commissioner Lau said he was open to that as well. How about,
I will move that the conditions of approval be amended to provide for a penalty of 5 times the normal permit application fee, and to otherwise approve the what is this?
You could move adoption of the resolution.
Yeah, thank you.
With the modification to the conditions.
Thank you.
and second?
I'll second.
Okay, all in favor? Aye.
Aye.
Okay, the motion passes with those conditions stated. I will now read the appeals process. Anyone may appeal the action of the Planning Commission to the City Council, except where specified otherwise, appeal shall be filed with the city clerk not later than 15 calendar days following the Commission's decision. Exceptions include appeals for use permits and variances, which are 6 days, and tentative maps and advertising sign applications, which are 10 days. An application form and fee are required. For assistance, you may contact the city clerk at 415-508-2110. Okay, next is items initiated by staff.
All right, thank you. We have an item tonight to introduce our planning intern. Daniel has been with us since July. He's doing wonderful work, helping us with a lot of research, data analysis. He also has assisted with staff reports, as you may have seen his name on the authors list for tonight's staff report. So we did just want to introduce him to you all. He will be back at the September 11th commission meeting to assist and probably present on a workshop scheduled for that date. So you will see more of him. But
Great.
We're very
Welcome,
happy to have him.
Daniel.
Welcome.
It's a pleasure to be here. Thank you, commissioners.
Okay. Okay, anything else, Julia?
We did have one question that was perhaps a repeat of conversations we've had before, but we wanted to take another temperature check and see if it's helpful for the commissioners to receive calendar invitations for these meetings. We don't always send them out, and we're trying to gauge if we really do need to do that for every scheduled meeting, or if you guys are able to manage the calendar through other means.
I don't need it.
I kind of like it. I have Outlook, it shows up, so I certainly don't.
It doesn't hurt.
Don't mind receiving them. Actually, and we didn't get one for tonight, I guess, because it's not here. Yeah,
Right.
okay.
It would never hurt.
Okay.
Thank you.
Okay, that is helpful.
Yeah, thanks for
Thank
asking.
you. Yeah. Okay, there's, I'll say the ADU ordinance is scheduled for next Thursday's council meeting for introduction and first reading. And I think that's it.
Okay, thank you. Okay, next is items initiated by the commission. So do any commissioners that would like to say anything or add anything? Okay.
No.
Okay. Well then,
We've sort of, every time, the last umpteen meetings, we've been one short. So I haven't pushed it, 'cause it's not that big a deal, but we should at some point revisit the time of our meetings to see what really is like the least inconvenient for everybody. But since,
I think at their last meeting, Commissioner Patel said he preferred this time.
did it?
I
Okay.
think everybody else was okay, but he preferred, this
Okay.
time, so.
Yeah, because earlier is bath time.
Okay, then never mind.
Okay, well, thank you, everyone. Then I will adjourn our meeting until the next regular meeting of September 11th, 2025.